Welcome back to Neighborhood Justice, where we bring you the most unbelievable stories of property disputes, neighbor wars, and sweet legal revenge. I'm your host, and today's story is about a power-hungry HOA president who made the biggest mistake of her life when she tried to force me into her association. Trust me, you won't believe how this ends. She thought she could intimidate me with lawsuits and legal threats, but I had news for her. Sometimes the hunter becomes the hunted, and Karen Jenkins was about to learn that lesson the hard way. Let me introduce you to the players in this suburban drama. My name is Marcus Thompson, and I'm a 34-year-old software engineer who bought what I thought would be my dream home in Maplewood Estates, a quiet subdivision in North Carolina. The house was perfect, a beautiful colonial with a large backyard, exactly what my wife Sarah and I had been searching for. We'd saved for years to buy this place, and it represented everything we'd worked toward. Then there's Karen Jenkins, and yes, her name really is Karen, which should have been my first warning. Karen is a 52-year-old real estate agent who lives 3 houses down from me. She's been the president of the Maplewood Estates Homeowners Association for 8 years, and she treats that position like she's the mayor of a small town. Karen is the type of person who measures a neighbor's grass with a ruler and sends violation notices if it's a 1/4 inch too long. She drives a white BMW SUV with a HOA president bumper sticker, wears her authority like a crown, and has never met a rule she didn't want to enforce twice as strictly as necessary. The supporting cast includes her loyal HOA board members, Richard Walsh, a retired accountant who treats HOA finances like Fort Knox, Sandra Mills, a former teacher who now spends her retirement citing deed restrictions, and David Park, a lawyer who provides free legal advice to the HOA in exchange for having his home improvement projects rubber-stamped without question. When Sarah and I first moved to Maplewood Estates, we fell in love with the neighborhood immediately. The streets were tree-lined and peaceful, the houses were well-maintained, and the community seemed perfect for starting a family. Our house sat on a corner lot with mature oak trees and a garden that Sarah was excited to cultivate. We'd done our due diligence during the home buying process, or so we thought. Our real estate agent had mentioned that most of the neighborhood was part of an HOA, but assured us that our specific property wasn't included. We'd specifically looked for non-HOA properties because we'd heard horror stories about overreaching associations, and we wanted the freedom to make our own decisions about our home. The deed we received at closing made no mention of any HOA restrictions, and our title insurance was clear. For the first 3 months, everything was perfect. Sarah planted her vegetable garden, I set up a workshop in the garage, and we enjoyed the quiet suburban life we'd dreamed of. We were friendly with our neighbors, attended block parties, and felt genuinely welcomed into the community. I even helped Karen's elderly neighbor, Mrs. Patterson, with her computer problems a few times. That peaceful existence came to a crashing halt on a Tuesday morning in April when I found a certified letter in my mailbox. The return address read Maplewood Estates HOA, and my heart sank. Inside was a formal notice stating that I was in violation of several HOA covenants, including having an unauthorized garden structure, Sarah's small greenhouse, inappropriate outdoor storage, my woodworking materials in the backyard, and failure to maintain approved landscaping standards, with planted native wildflowers instead of the required St. Augustine grass. The letter demanded immediate compliance and included a list of fines totaling $1,200. At the bottom, in Karen's distinctive handwriting, was a note, "Welcome to the neighborhood. Please contact me to discuss your immediate enrollment in our HOA and payment of back dues totaling $2,400 for the past 8 months. I was confused and angry. I called Karen immediately. There must be some mistake, I told her. My property isn't part of the HOA. My deed doesn't mention any restrictions. Karen's voice was sickeningly sweet. Oh, Marcus, I'm afraid there's been a misunderstanding. You see, when the neighborhood was developed in 1995, your lot was always intended to be part of the association. The previous owner somehow managed to avoid his responsibilities, but that doesn't exempt you. I've had my legal counsel review the situation, and we're confident that your property should be included." "That's not how property law works," I replied. "If my deed doesn't include HOA covenants, then I'm not bound by them." Her tone shifted immediately. "We'll see about that, Marcus. I'd hate for this to become a legal matter, but the HOA has resources and we're prepared to protect our property values. I'll give you 30 days to comply voluntarily, or we'll be forced to take other measures." That night, I started researching everything I could about HOA law, property deeds, and covenants. I spent hours reading legal documents, court cases, and HOA horror stories. What I discovered made my blood boil. Karen had apparently tried this same tactic with 2 other homeowners in recent years, successfully intimidating them into joining the HOA and paying thousands in back dues and fines. I also learned that North Carolina had specific laws about HOA enforcement and that covenants had to be properly recorded and included in property deeds to be valid. My deed was clean. There were no HOA restrictions, no architectural controls, and no mention of any homeowners association. I owned my property free and clear of any such encumbrances. But Karen wasn't backing down. Over the next few weeks, the harassment escalated. I received daily violation notices for increasingly ridiculous infractions. My mailbox was 2 inches too far from the curb. My trash cans were visible from the street for more than 12 hours, and my car was parked in my own driveway at an inappropriate angle. Each violation came with its own fine, and the total penalties were approaching $5,000. The breaking point came when Karen had a towing company attempt to remove my car from my own driveway, claiming it violated HOA parking restrictions. When the tow truck driver saw my deed and realized I wasn't actually bound by HOA rules, he refused to take the car and told me about similar incidents in other neighborhoods. That's when I decided to fight back, but I was going to do it smart. I started documenting everything. I kept copies of every violation notice, every fine, and every threatening letter. I installed security cameras around my property to record any trespassing or harassment. Most importantly, I began researching Karen and her HOA's operations in detail. What I found was stunning. Karen had been running the Maplewood Estates HOA like her personal fiefdom for years. The association's finances were a mess, with thousands of dollars in unexplained expenses and payments to Karen's own real estate business for consulting services. She'd been approving her own home improvements while denying similar requests from other homeowners. Most damning of all, she'd been collecting fines and fees from residents without proper board approval and depositing them into accounts that only she controlled. I also discovered that Karen had never actually had a lawyer review my property status. Her threats about legal counsel were completely fabricated. The HOA's actual attorney had left the association 2 years earlier after disagreeing with Karen's increasingly aggressive tactics. But I wasn't ready to reveal my findings yet. Instead, I decided to let Karen dig her own hole deeper. I started responding to her violation notices with polite but firm letters, clearly stating that I was not bound by HOA covenants and requesting that she provide legal documentation proving otherwise. Each time, she escalated her threats without providing any actual evidence. Meanwhile, I was building my case. I hired a real estate attorney who specialized in HOA disputes, and she confirmed what I already knew. My property was not legally bound by the Maplewood Estates HOA covenants. More importantly, she helped me understand that Karen's actions constituted harassment, extortion, and potentially fraud. The situation reached its climax on a Saturday morning in June. I was working in my garden when Karen marched onto my property with Richard Walsh and a man I didn't recognize. She was carrying a folder full of papers and looked more confident than I'd ever seen her. "Marcus," she announced loudly, "I've tried to work with you, but you've left me no choice. This is James Morrison, the HOA's new attorney. We're formally notifying you that the association will be filing suit against you for breach of covenant, unpaid dues, and ongoing violations. Your fines now total $8,200, and if you don't pay immediately, we'll seek a judgment that could result in a lien against your property." James Morrison stepped forward and handed me a thick legal document. "Sir, this is a formal demand letter. You have 15 days to comply with all HOA requirements and pay all outstanding fines, or we'll proceed with litigation. I should warn you that our legal fees will be added to your debt, and we have a strong track record of success in these matters." I looked at the papers, then at Karen's smug face, then back at the attorney. This was the moment I'd been waiting for. "Mr. Morrison," I said calmly, "before you proceed with any legal action, I think you should review the actual legal status of my property. I'm not sure Karen has been entirely honest with you about the situation." Karen's face flushed red. "Marcus, don't try to confuse the issue with technicalities. You live in this neighborhood, you benefit from our services, and you need to pay your fair share." "What services?" I asked. "You don't maintain my street. The city does. You don't provide my utilities. You don't maintain any common areas that I have access to. And most importantly, my property deed contains no HOA covenants whatsoever." Morrison frowned and looked at Karen. Mrs. Jenkins, you assured me that all properties in the subdivision were bound by the association covenants. They are. Karen insisted. His previous owner just found a loophole. But that doesn't change the legal reality. Actually, it does, I said, pulling out my own folder of documents. Mr. Morrison, as an attorney, I'm sure you understand that covenants run with the land only when they're properly recorded and included in the deed. My deed is clean, my title insurance is clear, and I have never been legally bound by any HOA restrictions. I handed him copies of my deed, title insurance policy, and a legal opinion from my own attorney. Morrison's expression changed as he read through the documents. After several minutes, he looked up at Karen with obvious frustration. Mrs. Jenkins, why wasn't I provided with this information? These documents clearly show that Mr. Thompson's property was never properly included in the HOA covenants. We have no legal basis for any enforcement action. Karen's confident demeanor cracked. But he lives in our neighborhood. He has to follow our rules. That's not how property law works, Morrison replied sharply. You've wasted my time and potentially exposed the association to liability for harassment. I cannot and will not file any lawsuit based on these facts. But I wasn't done. Mr. Morrison, before you leave, there's something else you should know about your client. I pulled out another set of documents, my research into Karen's financial mismanagement and abuse of power. I've been documenting Mrs. Jenkins' activities for the past 3 months, and I believe you'll find this information very concerning. What happened next was even better than I'd hoped. As Morrison reviewed the evidence of Karen's financial improprieties, self-dealing, and fraudulent collection practices, his face grew increasingly grim. The HOA president, who had seemed so powerful and confident just minutes earlier, was now stammering excuses and trying to backpedal. These transactions were all approved by the board, Karen insisted. Mrs. Jenkins, Morrison said, according to these documents, you approved payments to your own business without board vote, collected fines without proper authority, and deposited association funds into personal accounts. This could constitute embezzlement. Richard Walsh, who had been silent during the entire confrontation, suddenly looked very pale. Karen, what is he talking about? You said all the finances were handled properly. The truth came tumbling out. For years, Karen had been treating the HOA like her personal piggy bank. She'd created fake violations to generate fine revenue, approved questionable expenses to her own business, and used association funds to pay for improvements to her own property. The total amount involved was over $50,000. But the biggest revelation was yet to come. As we stood there on my lawn, with Karen's authority crumbling around her, my research had uncovered something even more damning. Karen wasn't just embezzling from the current HOA. She'd done the same thing at her previous neighborhood before moving to Maplewood Estates. She'd been forced to resign from that association under threat of criminal charges, and had moved to our neighborhood specifically to start fresh with a new group of victims. Morrison was furious. Mrs. Jenkins, you've exposed this association to enormous liability. I'm withdrawing as counsel immediately, and I strongly recommend that the board conduct a full audit and consider involving law enforcement. Karen tried one last desperate play. You can't prove any of this. It's all speculation and vendetta because Marcus doesn't want to follow reasonable rules. That's when I revealed my trump card. Actually, Karen, I can prove all of it. You see, when you had your board meeting last month to prove filing suit against me, you held it at Sandra Mill's house. What you didn't know is that Sandra's teenage son was live-streaming his gaming session from the basement, and your entire meeting was accidentally broadcast on Twitch. I have a recording of you admitting to collecting unauthorized fines and discussing how to hide financial irregularities from the association's accountant. The color drained from Karen's face completely. In that recorded meeting, she'd not only admitted to financial misconduct, but had also discussed plans to forge documents to make it appear that my property had always been part of the HOA. She'd essentially confessed to fraud while being unknowingly recorded by a teenager playing video games. Morrison shook his head in disgust. Mrs. Jenkins, I strongly advise you to retain criminal counsel immediately. This conversation is over. He turned to me and handed back all the legal documents. Mr. Thompson, the HOA will not be pursuing any action against you. I apologize for this entire situation. As Morrison walked away, Karen made one final attempt to maintain control. The board will hear about this. I'll have you voted out of the neighborhood." "Karen," I said quietly, "you can't vote me out of anything. I don't belong to your HOA, remember? But you might want to worry about your own situation. Because in addition to the evidence of embezzlement, I also have documentation of every threatening letter, every harassment incident, and every attempt to illegally enforce non-existent covenants against my property. That's a clear pattern of extortion and abuse of process." The final twist in this saga came 3 weeks later. The HOA board, now fully aware of Karen's misconduct, held an emergency meeting to remove her as president. But they discovered something that made the situation even more delicious. Karen had been so focused on harassing me and covering up her financial crimes that she'd forgotten to pay her own HOA dues. According to the association's bylaws, any member more than 90 days delinquent on dues was automatically suspended from holding office and lost voting rights. Karen Jenkins, the woman who had terrorized neighbors for years over minor violations, had violated the most basic requirement of HOA membership. She was not only removed as president, but was also facing a lien against her own property for unpaid dues and late fees. The new HOA board, led by a retired judge who moved into the neighborhood specifically to clean up the association, conducted a full forensic audit of the finances. They discovered that Karen's misconduct totaled over $75,000 in misappropriated funds, fraudulent fines, and inappropriate expenses. Criminal charges were filed, and Karen was eventually convicted of embezzlement and fraud. But the story gets even better. During the investigation, it came to light that Karen had been claiming to be a licensed real estate agent when her license had actually expired 3 years earlier. Several recent property sales she'd handled were invalid, leading to additional civil lawsuits and professional sanctions. The house Karen had been so proud of, the one she'd improved using HOA funds, went up for sale 6 months later when she could no longer afford the mortgage payments without her illegal income stream. The new owners turned out to be a lovely retired couple who actually read and respected property boundaries. As for me, I continued living peacefully in my HOA-free home. Sarah's garden flourished without interference, my workshop produced beautiful furniture without violation notices, and we never again received a single threatening letter about our property maintenance. The native wildflowers we planted became a neighborhood attraction, with several other homeowners following our lead despite HOA objections. The moral of this story is simple but powerful. Knowledge is the greatest weapon against bullies and fraudsters. Karen Jenkins spent years intimidating neighbors with false legal threats and fabricated authority, but she could only get away with it as long as people didn't know their rights. The moment someone took the time to research the law and document her misconduct, her entire scheme collapsed. Too many people assume that HOAs and their officers have unlimited power, but the truth is that they're bound by the same laws as everyone else. Property rights are fundamental in America, and no amount of bluster or intimidation can change what's legally recorded in your deed. When someone tries to bully you with fake legal threats, the best response is often to call their bluff with real legal knowledge. Karen's downfall also demonstrates the importance of accountability in community organizations. HOAs can serve valuable purposes when properly managed, but they become tools of oppression when corrupt individuals use them for personal gain. The residents of Maplewood Estates are now better served by leaders who understand that their role is to serve the community, not exploit it. Finally, this story shows that patience and strategic thinking often defeat aggression and fraud. I could have confronted Karen immediately with my research, but by allowing her to dig her own hole deeper, I was able to expose not just her harassment of me, but her systematic abuse of the entire community. Sometimes the best revenge is simply giving someone enough rope to hang themselves. The last I heard, Karen was working at a call center and living in a small apartment across town. Her days of intimidating neighbors and stealing community funds were over, ended not by matching her aggression, but by exposing her crimes to the light of truth. Justice, as they say, is a dish best served cold, preferably with a side of proper legal documentation and a garnish of recorded confessions. Remember, folks, when someone tries to abuse their authority, the best response is often not anger, but preparation. Know your rights, document everything, and never let a bully convince you that their illegal behavior is somehow your responsibility to tolerate. That's all for today's episode of Neighborhood Justice. If you enjoyed this story of HOA Karma, hit that subscribe button and share your own neighbor war stories in the comments. Until next time, remember, the truth always wins in the end, but sometimes you have to help it along with a little legal research and a lot of patience.